Good evening. This is Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting, and also a venture capitalist. As we speak, Treasury Consulting Group is a multinational headquartered group based out India, Singapore, and Hong Kong. More importantly, we do have offices in 3 parts of the globe, and apart from that, we operate our own hedge fund. Now, it's a proprietary hedge fund. By definition, proprietary means we invest our own capital. We do not invest anybody's capital. So, we never take third party capital. We only invest our capital, which means the money of Treasury Consulting. Just like United States hedge funds, we take positions in FICC, fixed income, currency and commodities, and crypto. More importantly, we do not accept anybody's money in any asset class. That is more important thing. As an organization, we are 100% profitable since inception. Apart from that, the company do invest the money with the mutual funds, the top banks of the globe, and earn a very decent income. With $0 backing from any venture capitalist and private equity firm. This is Treasury Consulting. Apart from that, we have our news desk, our Learnings Academy, our FNO Learnings Academy, our OTT platform TRFX, and many more products. In case you wish to have any information, you can WhatsApp on my personal number, which is +91 9899 242 978. Alternatively, you can WhatsApp on our back office, which is +91 9818 485 155. As you understand that Treasury Consulting enters law, and now we have started making the videos on the law. And one of the important things we would be covering about law is the Indian Arbitration and Conciliation Act 1996. And today I would like to speak about two important things. One is the theory, rather a redundant theory. One is the practical, the real life scenario. So first speak about the redundant theory. If you look at section 20 of Indian Arbitration and Conciliation 1996, there is a term called place of arbitration. But that is absolutely ambiguous. Now in ambiguous, in English, the ambiguous means multiple meanings. Because there are two things which we have in international arbitration clauses, in arbitration clauses in international contracts or international arbitration, which is number one, the place of venue. The seat of arbitration. And second is the venue of arbitration. So let's take a simplistic example. This is a hypothetical example which I'm taking. Please don't consider this as a, of course it do happen similar example, but doesn't mean the entities which I'm using, they did that. So this is a hypothetical example. Amazon India is tying up with any t-shirt maker. And Amazon India saying we need 20 million t-shirts. We expect in the first week of New Year, we have a huge sale and we are looking forward to have 20 million t-shirts. They agreed with the pricing, assuming it is $20. Hypothetical example. And the vendor who would be providing 20 million t-shirt is agree with $10. He thinks that he is able to make a margin. Amazon think $10 is okay, no worries. Okay. Unfortunately, the vendor is not been able to provide that 20 million t-shirts to Amazon, or even if he is able to provide, there are quality issues with the t-shirt. And Amazon facing heavily complaint about this t-shirt. So ultimately they are incurring double losses. So what do you mean by double losses here? Like Amazon having a policy, like I'm a permanent customer to Amazon Prime member. Amazon having a policy that if you buy anything within 10 days, you can return. And by the way, their return policy is very effective. There is hardly any doubt about that. So I even have no words. Very effective, 10 out of 10, to be honest. So in this 20 million t-shirt, people bought the t-shirt and they started complaining the quality issues, the apparel issue, size issues, whatever mentioned on the website is not telling what they got, something like this. So of course within the 10 days you can return that. Amazon take this return. So whenever Amazon take this return, they don't charge anything. It is a cost to Amazon. So what happens, since it is a cost to Amazon, Amazon wrote an email to his vendor and say the product you supplied is completely worthless, which ends up, forget the profit, which ends up double cost to me, and now you need to pay me the losses. Now the contract which Amazon India and that vendor signed do not have the seat of arbitration. First of all, 99% contracts signed in India never have arbitration. Hardly 1% contracts have arbitration. And even if these 1% contracts have arbitration, they do not mention the seat and the venue of the arbitration. Now there is no seat mentioned. Since there is no seat mentioned, Amazon would like to arbitrate this in Singapore. Now, why Singapore? With due respect, Singapore is more efficient. We have seen in the case of many arbitration in the Indian corporate fights that the efficiency of Singapore is much, much, much better than you have in India, at least in arbitration. Rather, being a Singapore-based company, Singapore is known as an Asian hub of arbitration. Now, this t-shirt vendor who is based out India is saying that he cannot afford Singapore because Singapore would be very costly. The lawyer would be charging a huge amount of money, the travel cost. But Amazon is saying since the contract is silent about the seat of the arbitration, so we are taking this to Singapore. Now the t-shirt maker is gone because there is no arbitration clause. As simple as that. Since there is no arbitration clause, he is helpless. He cannot do anything. He is defenseless. This is called seat of arbitration. One is venue of arbitration, which is much more important than seat of arbitration. So let me give an example of venue of arbitration. I'll take the same example but little twist. Amazon, not Amazon India, Amazon Global. Many entities of Amazon want this t-shirt. So they would be selling this on a global level. Since they would be selling this at the global level, multiple entities of Amazon are involved. Amazon US, Amazon London, Amazon Sweden, Amazon India, Amazon Singapore, Amazon Malaysia, and many such. They are involved. Very good. Now the vendor, he is also a multinational company. He sells apparels worldwide. Oh, they signed the seat of the contract, but they forgetted the venue of the seat of the arbitration, but they forgetted the venue of the arbitration. Now, what the hell is that? Since multiple entities of the Amazon is involved, you need to sign the venue of the arbitration, which means that the seat can be London, but venue can be anywhere in Asia. Now, what does that mean? Seat means the loss of arbitration. So when you say the seat is London, the British law of arbitration would applicable. When you say the seat is New York, the New York law of arbitration is applicable. When you say it is Malaysia, the Malaysian law of arbitration is applicable. So when in the contract they mention seat as London, it means the British law of arbitration is applicable. It means both Amazon entities, whatever, Amazon India, Amazon US, Amazon Singapore, Amazon Europe, who ordered the t-shirts, they are aware the pros and cons of the British Arbitration Act. And the vendor, the multinational company who is providing that t-shirt, he's also aware about the British Arbitration Act. Another is the venue. Since the British Arbitration Act would be applicable, but that doesn't mean you have to go to Britain, you can have a venue in India. So this company is saying, I agree, British Arbitration Act would be applicable since seat of arbitration is Britain, but the venue would be India, or maybe Singapore, or maybe any country. That is the exact difference between seat of arbitration and venue of arbitration. But when you look at Section 20 of the Indian Arbitration and Conciliation Act 1996, as usual, it is ambiguous, nothing new. It mentioned place of arbitration. Now, what the hell is place of arbitration? Why don't you write venue of arbitration, which is an international practice? Because place is an ambiguous word. Henceforth, all the contracts which are done in India, it is the duty of both the parties to be specific as far as the seat of arbitration is concerned and the venue of arbitration is concerned. But guys, remember, in seat and venue, seat is more important. Example, you are choosing the seat as New York, venue as India. Probably you are not aware about the New York Arbitration Act and you're just making the seat as New York. And later on you get to know that there is no competent lawyer you have in India who can litigate this case. Now you need to have a lawyer from outside India. You need to bear his travel cost, his accommodation cost, his charges and everything. So before choosing the seat, remember carefully that applicable talent should be available in that country. So example, I'm choosing seat of arbitration as New York and I'm a Singapore based company. I should know that how much a lawyer is charging, once he's going to litigate the New York law, compared to if I choose the seat as Singapore. So that differential. So assuming in Singapore, the lawyer is available $300 per day, while in New York, it is available $1,000 per day, which means 3 times. That's very important. Please do note that. Second important thing, I would like to integrate this, which is ASC 805. ASC stands for Accounting Standard Codification, or I can say FAS, Financial Accounting Standard 142R, which is nothing but the business combinations. In business combination, there is a concept called VIE, Variable Interest Entity. Now, what the hell is that? Let me take a simplistic example again. Now, this is again an example, right? This is again an example. Please don't treat this as a real time. Basically, it happens that way, but doesn't mean the entity which I'm quoting, is actually doing that. Please note that. Twitter wanted to enter in space tourism. Twitter is a news company. Now, what the hell is space? But Twitter feels that it is a growing area and they can enter in space. Good. But Twitter also feels that their main focus should be on their news rather than on the space. I again repeat, this is a hypothetical example. So rather than merging the space with the main business, what Twitter will do, Twitter will create a SPV or SPE. Now SPV means Special Purpose Vehicle. SPE means Special Purpose Entity. Now what is the difference between Special Purpose Vehicle and Special Purpose Entity? The difference is Special Purpose Vehicle can have multiple entities. So Twitter wanted to float Special Purpose Vehicle on balance sheet. And they want the help of Amazon US because now Amazon is a leading player in space. We know that. To help them in this space technology. Now, for that, they make a special purpose company, a special purpose vehicle, and this is in the consolidated balance sheet of Twitter. But this is just one thing which Twitter is doing but the main revenue of Twitter is the advertisement, online advertisement, which is basically the news, which a news platform. So Amazon is signing a contract with that SPV, not with the Twitter. Amazon is giving services to that SPV, not to the Twitter. Any dispute between the services, the quality of the services, the pricing, the infringement, the copyright infringement, the sale of technology, TOT, transfer of technology, and many things is between that SPV and Amazon. Now, when I say Amazon, I mean Amazon US, hypothetically. This difference or twist or any kind of disagreement has nothing to do with the Twitter. It has to do only with the SPV of the Twitter. This is called VIE, Variable Interest Entity. Now, what is happening? Variable interest entities are generally set up when the company, in our hypothetical example, it is Twitter, do not have the SME capability. SME means subject matter expertise. For that, they need the third party, and the third party is Amazon in this case. But having said that, the most important thing, having said that, the arbitration or whatever the contract which Twitter is signing with Amazon, they need to be clear that the arbitration is between that VIE, Variable Interest Entity, and Amazon US, assuming Amazon US is providing that service. There is a twist, and that is, what would Amazon also having a VIE, Variable Interest Entity, who is providing the space services? So rather than creating this as a legal entity, Amazon created VIE, Variable Interest Entity. So the variable interest entity of Twitter and VIE of Amazon are doing business with each other on space. So the arbitration is between these two entities. Arbitration is not between Twitter and Amazon US. Arbitration could be because of pricing dispute, could be the quality of the services, could be the infringement of the services, could be the intentional selling of technology belongs to Amazon to the third party, could be leaking of technology, could be transfer of technology, many things. Henceforth, when we speak about VIE as per 142R, FAS, Financial Accounting Standard US GAAP. In fact, it is there in the IFRS also, IFRS 3, which is business combinations. We need to be very alert on that. Henceforth, when we speak about Section 20 of the Indian Arbitration Act and Arbitration and Conciliation Act 1996, as usual, it is ambiguous, nothing new, at least to me. But rather than using the place of arbitration, it would be great if the act mentioned the seat of arbitration, which is nothing but the law of that country, and the venue of the arbitration, which could be anywhere. So if I go with the example of Twitter VIE and Amazon VIE, hypothetically, they have made the seat as New York. Since Twitter is a US based company, Amazon is a US based company, so they made seat as New York, which means the New York seat, the New York law would be applicable. But they made venue as Singapore, which means it is litigated in Singapore, but as per US Act. In the next video, I speak about co-venue. Indian Arbitration and Conciliation Act 1996 is extremely silent about co-venue knowledge. But now, as the world economy is moving, it is integrating very fast. The technology is helping people. After COVID-19, it is more or less the online world. There is a new concept which is coming up in the arbitration, which is called co-venue, which we speak about next video. As promised, Treasury Consulting is in law now. And on a very frequent basis, we would be covering those topics of the law, which I don't think anyone would be touching. This is Rahul from Treasury Consulting Group. You know my personal number, which is 9899242978. In case of any questions, you can definitely WhatsApp me if you feel the question deserves our reply. That's more important. Else, it would be on a consulting basis. Thank you very much, sir. Have a great time ahead. Thank you.